this lecture we shall discuss credit delivery. Friends, credit delivery involves lot many activities, and one of such activities is documentation. So precautions or procedures to be adopted while doing the documentation. After sanction of the loan, the security documents are got signed, and these documents should be signed either by the borrowers or their authorized representatives. In case guarantees have been obtained, then these should also be signed by guarantors. What is objective of documentation? Friend, documentation creates evidence, and it also creates a charge over loan securities. So the securities which have been created, the assets which have been created or which are to be created by using the bank loan, the charge over those securities is created through documentation only. In certain cases, the charge created on security requires to be registered. So this registration is another requirement under documentation. Under Indian Stamp Act, number of documents are required to be stamped. So payment of stamp duty, appropriate stamp duty payment is also an important requirement of documentation. In certain cases, the documents also require attestation, that is witnessing. So wherever the law requires a document to be witnessed, it must be got witnessed, it must be got attested. Date of documents. Precaution should be taken that date of document must not be earlier to date of payment of stamp duty, because stamp duty is required to be paid before signatures. So hence date of document must not be earlier to date of payment of stamp duty. Date and place of execution on the documents must be mentioned. Date has the relevance with regard to the limitation period or due dates, and place of execution has the relevance for filing suit in case of need. Hence, date and place of execution must be mentioned very, very clearly. It is possible that a document is dated more than one date. So document with more than one date is a valid document. But in that case, the date of a document shall be treated as the latest date in the document. So when a document has more than one date, then it will be dated as latest date in that document. Documents with more than one place. If a document is signed at more than one place, it also is a valid document, but there is a condition. The condition is appropriate stamp duty must be paid for all the places, for respective places. So a document with more than one date, a document with more than one place is also valid, but then these precautions must be taken into view. Person signing documents should have proper authority and capacity. In case of individual borrowers, normally borrowers themselves signs, but in case of companies, the authorized person sign. So the person who are signing the document, they must have proper authority and capacity to sign the documents. Documents are to be filled before signatures. So documents should not be left blank Wherever it requires to be filled in, it must be filled in before signatures. In case of companies, the details, the particulars of charge must be filed with ROC within 30 days for registration of charge. When loan is given to a company, it is requirement of Companies Act 2013 that details of all charges must be filed with the Registrar of Companies, and for that purpose there is a time limit of 30 days. Similarly, in case of immovable properties, there is a requirement of registration of mortgage deed with sub-registrar, that is Registrar of Assurances. And this must be done within prescribed period of 4 months. So where documents are required to be registered with the sub-registrar, these must be got registered within a period of maximum 4 months. So these were the requirements relating to documentation. Now let us take the second part, third party guarantee. If a guarantee for the loan is taken from third party, what precaution should be taken? Friends, that guarantor can be an individual person or it can be some legal person like a company. So guarantee can be given by individuals also, guarantees can be given by legal persons also. Guarantees can be given by third parties also, guarantees can be given by promoters also. In case of companies, if personal guarantee of directors is taken, that is very useful for recovery of loan and in continuation of management. If bank wants that the current management, the present management should continue, then personal guarantee of directors is very useful. And in case loan goes bad, in that case also recovery of the loan, it becomes little easier if there is a personal guarantee of the directors. Guarantee of parent company can also be taken where financial position of subsidiary company is not satisfactory. So when loan is given to a subsidiary company and its financial position is not up to the mark, bank is not satisfied with that, in those cases the banks can obtain guarantee from the holding company or parent company. Guarantors are not to be given any commission or brokerage fee. So bank must ensure that the borrower does not make payment of any commission on brokerage for the guarantee given by the guarantors. So after rules relating to guarantors, let us now see the charge over securities. Charge over securities. The charge could be in any of the following. So this means there can be various types of charges. The charge depends upon the nature of security, the type of security. In case of immovable properties like land, building, ship, etc., mortgage is created. In case of actionable claims like book debts, like bank FD, like life insurance policy, NSC, etc., assignment charge is created. In case of movable assets like stock, vehicles, plant machinery, where they are in possession of the borrower, hypothecation is created. So for movable assets, where they are in possession of the borrower and where ownership is with the borrower, hypothecation is created, like in case of vehicle loan or loan against plant machinery. Lien. Lien is created primarily in case of securities mainly. So lien is created in case of securities, like in case of shares. When loan is given against shares, lien is created. Pledge. Pledge is also created in case of goods, movable assets like stock, like plant machinery, etc. But then pledge is created when the possession is with the bank and ownership is with the borrower. And this possession can be actual possession, this possession can be constructive possession. Possession is called to be constructive possession when it is with the agent of the bank. So these are various types of charges we see from this. Depending upon type of security, nature of security, the charge to be created is different. So proper documentation is required to be taken to create this charge specific to a specific security. Well friends, we shall continue with this in next lecture also.